All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We're here for argument in our case number CV220523 KS State Bank versus Hunter Financial. Council, a couple of reminders. We're recording and live streaming the argument, so please identify yourselves and your clients at the beginning of your arguments. Each side will have 20 minutes. Appellant's counsel, please reserve as much time as you'd like for rebuttal by watching the clock. Also, keep in mind we've read the briefs, we've studied the record, we've also reviewed the supplemental briefing, we've discussed this case in conference. Counsel for appellant, you may proceed.
May it please the court, my name is Cameron Artigue. I'm here for appellant Kansas State Bank. The trial court determined that my client's deed of trust is valid and enforceable and secures the entire unpaid loan balance. It sounds like a prosaic fact, but I'll probably come back to that. It's undisputed that my client's deed of trust secures everything. All the future advances, everything. The trial court also determined that the subordination agreement signed by Hunter Financial is, at least to some extent, a valid and enforceable subordination agreement. So if that's all they told you in your secured transactions course, that we have a valid deed of trust that secures a whole bunch of debt, and then we have a second lender who says, I will subordinate, I subordinate to that first deed of trust, that's enough to decide the case. That finishes the case. Unless, and here's where we get into the meat of it, the trial court discovered in the subordination agreement a sort of implied, buried limitation in terms of the dollar amount to which Hunter Financial had subordinated. And that's what brings us here. And that was the trial court's error, respectfully. So we're here on a sort of hunt for some kind of limit or constraint on the scope of the valid and enforceable subordination agreement. Okay, this is a little bit of like a film noir, because I'm going to go looking for the constraint. The first place you would logically look for a limit on the scope of the subordination agreement is within the four corners of that agreement. And it's obviously in the record, and there's the limit determined by the trial court is $1.168 million. Well, that number's not in the subordination agreement. It doesn't appear there. The only dollar amount that appears in the subordination agreement is $256,000, and that appears in a recital that refers to the deed of trust to which Hunter Financial is about to subordinate. And so, think about this. If you said, well, I'm going to have a subordination agreement, but there's going to be a limit to how much I'm subordinating to, that's not hard to draft. This subordination agreement shall only apply to the first $1.168 million. Or provided, however, that we're only subordinating up to this amount. You could draft such a thing. But it doesn't appear anywhere in the subordination agreement. To the contrary, and I'm reluctant to stay here and quote the agreement to the court. We've done that plenty in the briefs. But the word unconditionally appears 5 times in that subordination agreement. Hunter Financial says that they agree to subordinate to the deed of trust and any extensions thereof unconditionally. And unconditionally appears 5 times. So it's not in the four corners of the subordination agreement. And that's not where the trial court purported to find this limit. Yes, Judge.
The subordination agreement also doesn't say that it will subordinate to optional versus mandatory loans under the TROIA. That's not there either.
I would push back on that. It does say they subordinate to extensions of the deed of trust, and they consent to all provisions of the deed of trust. And the deed of trust, and this is where we sort of pivot to let's look at the deed of trust. The deed of trust itself secures future advances.
But doesn't make any of them mandatory. They're all optional.
That's right. That's right. That's why we did the subordination agreement.
But if you wanted, if the goal was to subordinate future voluntary under the law as it stands with La Cholla, why wouldn't your client have said, as to these people, we're going to expressly say that? You just made the point that it didn't expressly say one thing. Why didn't it expressly say the other?
Well, this deed of trust secures future advances. We know that because that's what the trial court determined, and that's what's undisputed, that it secures the whole thing. Hunter Financial is asked, will you get in line behind this deed of trust, which secures optional as well as obligatory advances? We know that it does because that is undisputed. So Hunter Financial has, by signing the subordination agreement, they have said we're subordinating to a deed of trust that applies to optional and obligatory. I mean, again, that is why we entered the subordination agreement. When
Kansas State isn't actually a party to the subordination, is it?
That is true. That's
So
true.
you didn't enter into it. Two other people.
Well, no, the subordination agreement is entered contemporaneously,
Right.
but the subordination agreement is like a rider to the original deed of trust. And in fact, Hunter Financial's, the nomenclature is they're the beneficiary of the subordination agreement.
It's a different thing.
It's a different thing. But they say in that subordination agreement, yeah, we have this deed of trust, but we agree to subordinate unconditionally to KS State Bank.
So let's say another lender comes along after Kansas Bank does the 2017 loans and in 2018 loans another $1 million. They're not subordinated to your voluntary loans.
No, they're not.
So the same language you're saying because of the subordination alone makes Hunter subordinated to your voluntary loans, but future lenders not.
Well, the future lenders would be subordinate because they come later in time.
Not for voluntary. That's what La Cholla says.
But if right,
They're
that's
not mandatory.
That's correct. But if in 2018 another lender entered the picture and looked at the record and said, yes, there's a deed of trust from Hunter, there's a deed of trust from my client, there's a subordination agreement, the phone calls would be made. That's what title companies do. We figure out what is the status of loans, and at that point, that lender can decide to make whatever loan they want to make, and they would be junior to both.
Well, where? How? Because La Cholla doesn't say they would be junior under your deed of trust. La
Well, they're
Cholla
junior
says-
because their loan would only be made in 2018.
Right, but on priority, in terms of priority, their priority would only go to the extent of the loans made before, I'm sorry, it should be before. I did misspeak. So before you jumped in and your client jumped in and did the 2017 loans, they loaned $1 million. They would have priority because they were made before with no voluntary loans in the pipe.
Well,
And these later loans under La Cholla couldn't have priority over them because they were voluntary.
I'm not necessarily, I guess I'm not following, Your Honor. I mean, my client, it is undisputed that my client's 2017 loans are secured by the deed of trust. And it is our contention that they are covered by the subordination agreement because the subordination agreement says you agree that here's the deed of trust.
And I understand that.
And so.
But my problem is and this is the challenge you need to walk me through.
Okay.
Once you make the deed of trust, under the deed of trust, there were no mandatory loans. They were all voluntary.
Yeah, I mean, that point.
Well, let's just go with that.
Okay,
That's true.
Let's assume that.
That is, well, it's there. And I don't think you've contested that here. So we've got only voluntary loans are going to be made after that deed of trust. Another lender could come in before those 2017 loans, make a loan, and they would have priority under the deed of trust as to your client's later 2017 loans, because La Cholla says voluntary loans made later don't get priority.
Yes.
Okay.
Yes, that's true. If another lender had appeared in late 2016 and made a loan, you're right. My client, before dispersing the 2017 loan, would have said, gosh, another lender's popped up. And so you're right. LaToya would have applied in that circumstance, Judge.
So now, because what the law is designed to do is give predictability. Because you're asking us to accept that that would be true and that your voluntary loans were subject to the deed of trust. Tell me where that later 2016 loan stands with priority to Hunter.
It's senior to Hunter because Hunter subordinated to everything that was secured by the 2014
So Hunter didn't just
and
take
2016 deed of trust.
So Hunter didn't just take what you might voluntarily do. Hunter took what anybody else might voluntarily do also?
I'm not saying that. Hunter subordinated to my client's 2016 deed of trust. And however, whatever that might secure, past, present, future, Hunter said, we will be in line behind that. And if my client lends money to be secured by that 2016 deed of trust, Hunter is subordinate to that.
And anybody who would at least agree might come in between the 16 and the 17 loans.
Well, no, I acknowledge your owner's hypothetical is correct. If another third party that didn't have a subordination agreement had entered the picture, then, the story would be different. Yeah.
Hunter gave up everything. Because then let's say you made the 2017 loan, someone else came along, loaned more. Hunter, your client makes some more loans. Hunter is always going to stand behind everybody at that point.
No, I'm not attributing that effect to Hunter's subordination agreement.
So we take the same language and would read it differently for different people. Identical language would get different treatment.
Well, it is. The subordination agreement refers to and subordinates to one specific deed of trust, my client's. It doesn't say we'll stand at the end of the line as to the world. It says we will stand behind whatever is secured by the 2016 deed of trust.
And as long as there is a loan after a loan by any other party from your client, Hunter has to stand behind that.
That's correct.
So basically, you're saying that Hunter did exactly what all the cases say lenders don't do, which is give up all of their interests. Because Hunter could never really get in front.
Well, but this is the consequence of signing a subordination agreement when you're a commercial lender.
So where in the subordination agreement does it say we will disregard Troya and the law? Is there anywhere in there that's there?
Well, I guess Troya is a common law rule. Okay, if the common law rule is, I'm trying to think of a common law rule that, there's an assumption of risk that applies in a personal injury situation. And somebody says, well, we don't want that common law rule to apply. We're going to obviate that by entering a contract. And Hunter, in their brief on page 17, says, the point of the subordination agreement was to readjust the priorities that otherwise would have obtained under LaToya. That's the point of the subordination agreement.
Under LaToya, it would not have lost priority for later voluntary loans.
Correct. And under
but it didn't say that we were giving up that priority. If
it did.
Wanted them to give up, why didn't your client say we want that in there? Because we're reading the plain language.
The plain language of the subordination agreement says you will stand behind, you agree to this deed of trust. It's referred to. Here is the deed of trust to which you are subordinating. That deed of trust secures not only the $256,000 that's on its face, it secures future advances. We know that because the trial court held that it secures future advances.
But then we have to say that they assumed that this Troya would never apply because your deed of trust didn't have the mandatory loans that would subordinate those future loans to.
The deed of trust contains everything it needs to contain to secure future advances, and that's the point of a future advances cross-collateralization clause, is you're securing future optional originations.
And I would agree 100% if these were mandatory loans. My problem is these were not. So why do I disregard LaToya? Maybe that's the question I should ask.
You disregard LaToya because the only two entities in the world who are even arguably protected by the LaToya rule. Why does the LaToya rule exist under the common law? It exists to protect a second lender, who is Hunter, and maybe it exists to protect Dennis Sabin, the borrower. There's a theory that you can sort of enable people to unlock the equity in their home. Well, those are the two parties who executed the subordination agreement, Sabin and Hunter. And that's why they did. Because there's a LaToya rule, there's a common law rule that would dictate this result. This is where the chips would land under the common law, but we're going to obviate that. We're going to use a subordination agreement, which does not appear in LaToya, to reorder the priorities, which is what Hunter says on page 17 of its brief, and that's the intention of the subordination agreement.
But then the question is, how far did it go? That's where LaToya kicks in. And LaToya says it doesn't go beyond mandatory loans. It goes the amount, the interest, the principal may be owing, and mandatory future advances, but it says it doesn't extend to voluntary or optional future advances.
Well, but that is the common law rule that has been obviated. I mean, LaToya, with respect, Your Honor, I don't think LaToya applies anymore. When you sign a subordination agreement that says, hey, there is a deed of trust on the table that secures future optional advances, I'm going to subordinate to that.
But that's a deed of trust. Why isn't that deed of trust subject to the common law, i.e. subject to LaToya?
Well, it would be, but for the subordination agreement. I mean, but when you go to Hunter and Sabin, who are the parties that, would benefit from the LaToya rule and say, hey, Mr. Sabin wants to borrow additional money from KS State Bank. KS State Bank wants to ensure it has priority. They don't want to have to deal with the LaToya implications. So would you please sign this subordination agreement so that Hunter stands behind, will occupy a junior position to this deed of trust, and they say, yes, we will agree to that.
So below, nobody argued that we would look at anything other than the plain language. So there's nothing before us for parole evidence. No evidence that Kansas State Bank said, hey, we're trying to get around the LaToya. No evidence going the other way. All we have is the plain language.
That's correct. It's litigated as a summary judgment case. Yeah.
And so the plain language is what we have to deal with. And your reading of the plain language would have us read the plain language in your deed of trust differently for Hunter than we would read it for any other lender.
No, I haven't agreed with you on that point, Judge.
Well, LaToya would apply to any other lender, correct? Or you say any other?
And LaToya might protect other lenders. Yes, if there's a difference between Hunter and some other hypothetical lender, it's the fact that other hypothetical lender hasn't voluntarily subordinated. If another hypothetical lender appeared, as Your Honor posited in late 2017, yeah.
So we have to read your deed of trust, this subordination agreement for your argument to hold. We have to read it that Hunter agreed to subordinate to you, your client, and to any future lender who may also get a priority, because we're going to read them. Because if you had $1 million lender between 2016 and your 2017 loans, they have priority over you, your client. They have to go in line before Hunter, then your client.
Well, yeah, but here's the difference.
So you're saying that we have to read it to the point that Hunter subordinated, basically gave up LaToya to everybody.
No, I disagree. Hunter only gives up LaToya and only agrees to subordinate as to my client. If some other hypothetical lender had come into the picture, they would be junior. They would get the benefit of LaToya. They would be, junior to Hunter. They would be a third position. And if in 2018
if they had priority over Kansas Bank for the 2017 loans, they could never be junior to Hunter, because you're client is got primary to Hunter, has priority.
Well, you're right. I
So
mean,
you're creating a math problem with your reading, is the way I see it.
no, I think that my view is my client's senior, and that was the trial court's view, at least for the first 1.168 million.
Right.
Second is Hunter. If you have this hypothetical lender enter the picture in 2017, 2018, they're junior to both.
Not if it was a voluntary loan. In other words, because they're not junior under La Cholla if they made the loan before your client gave the 2017. So I'm asking you for a hypothetical. Somebody came in and made a voluntary loan to them, and all your client had was the La Cholla priority as to them. So now they've got their $1 million priority as to your client. Got it?
Yes. If some third-party lender had entered the picture
Right.
before my client made its final loans,
Right.
my client could not and would not have said, well, we're covered by a subordination agreement, we're good, let's go ahead and make those loans. They would have said, there's this new, fresh security interest of record that we need to think about, deal with, take
So your
care
client
of.
makes the loan.
Made the loans.
But let's say your client makes the loan. That's for my hypothetical.
Then we would lose priority
to them,
but
not to Hunter.
Correct. Because Hunter subordinated.
So where does Hunter stand then when you say we've lost priority? Because you're saying I'm in front of Hunter and they're in front of me, but they're not in front of.
No, this hypothetical lender we're discussing, and I'm out of time, but this hypothetical lender we're discussing would be junior to Hunter because they're later in time, and arguably, it would be, just because of the junior in time rule, they would be junior to Hunter, and they would be junior to my client because of the junior in time. My client would remain senior to Hunter because of the subordination agreement, but my client would not have been able to make the last, disbursement because we only had a subordination agreement as to Hunter.
That assumes your client would decide to take the risk. They could have made that.
Correct.
So
Yeah, no,
I'm asking you what happens if they do, because lenders do all the time.
Right. Yes. Judge.
Counsel.
Oh, thank you. I took a question. Thank you.
Thank you. Mr. Holohan.
May it please the court, I'm Brian Holohan. My client is Hunter Financial. We've referred to Hunter Financial as HFI in the briefing. I'll do that today, if that's all right. I came prepared today to argue the two questions that the court posed, assuming that's what the court wanted to hear. But my opponent started down a couple of side roads that I just feel obliged to address. The first is this notion. He keeps saying that it's an undisputed fact that the notes 3 and 4 are secured by the deed of trust. Well, first of all, that wasn't decided as a fact. The judge made that legal conclusion. And second of all, it's not undisputed. That's why there's a cross appeal. Second point, they continue to argue the subordination agreement and have at least implied that we're agreeing with their position. Obviously, we're not. Do we admit that the HFI lien was subordinated to the lien that was created by the 1.168 million note? Yes, that's all we've agreed to. And here's a fact that seems to escape the bank's attention. The note, the so-called note number 2, it's a fully amortized note. Those are not the kinds of loans that lenders advance additional funds in the future. It's not a line of credit. So when my client HFI agreed to subordinate to note 2, what it knew was that that was a $1.168 million obligation, period, end of story. Now, I want to pick up on Your Honor's questions about subsequent lien holders. I think I can fill in the syllogism that you were trying to make, which, by the way, I agree with. If the bank is right, if the subordination agreement made HFI Jr. to these later optional loans, and a lender came in between the last bank loan and the 2017 loan and made a loan, they would be superior to the bank. Well, if the bank is superior to HFI, then necessarily HFI is subordinate to the later lender who's superior to the bank. And that can't be what the agreement was. It makes no sense at all. Final point on the subordination agreement, and then I'll move away from that. If one reads the subordination agreement, all HFI did was consent to and approve all provisions of the note and deed of trust in favor of the lender above referred to. That's note 2. Now, we agree that HFI was subordinated to note 2 by virtue of the deed of trust, but that's not the same thing as agreeing in advance to be subordinated to optional advances. All right. Now,
Or to waive the common law rule.
exactly. Right.
Common thing to say, if you want to do that, is we waive this rule or whatever.
Well, certainly it would have said something
If
more
it was
than,
something folks wanted to do.
yeah, it would
What
say
if it
something more
said
than,
notwithstanding any other law to the contrary, or something like that?
it would have said something, and it doesn't say anything. All right, let me address the 2 questions that the court posited. The first one was about the interplay between the maximum lien language and later mandatory advances. And the response, it seems to me, is very simple. A maximum lien is a maximum lien. And if KS Bank made advances in advance of the maximum lien, it can't be secured as to that, because what my client saw when it examined the record was a deed of trust that said maximum lien. And it's interesting on that point, in the opening brief, KS argued this: lenders have no obligation to disclose the amount of an obligation in a deed of trust. But if they do elect to do so, the law protects third parties from being misled. The key recurring issue is the treatment of future advances. In other words, a lender's extension of additional credit after a deed of trust is recorded. A third party is entitled to fair notice that the amount of mortgage may be increased. Well, how was my client given that fair notice when the document on his face said, this is the maximum amount our lien will ever be? And given that, I can't envision a scenario in which obligatory advances made in excess of the amount of the lien limitation could have la choix priority.
So let me ask you this, because the record seems clear that if the 2017 loans aren't protected, and this is just so that I'm clear on the record, then the maximum lien amounts don't get triggered at all.
Correct.
So it's only if the 2017 loans are governed by the subordination agreement and roll in that we even look at that.
Yes, Your Honor.
I just want to make sure that
That's why we've pointed out in the brief, if you agree with us on that point, you avoid all these other sticky questions. Now, they're not sticky, but they're issues you'd have to decide if you conclude that notes 3 and 4 are secured. Going back to the maximum lien language, I tried to think of a scenario in which a lender would put both maximum lien language and future advances clause in the same instrument, expecting to be able to lend more than the maximum lien amount. I can't come up with one. The closest I can come to is if the loan to Mr. Sabin, note 2, had been a revolving line of credit where it gets paid down and sometimes it gets borrowed back up. Well, that's a reason that the maximum lien language would be put in there so that my client would be put on notice that even though it started at 1.168, it may get paid down, but it may get drawn back up to 1.16.
But doesn't the future advances actually give your client that? It in fact creates a revolving line of credit where they could pay it down. Let's assume that we treat the maximum loan the way you want to. They could 5 years from now, it could be half paid off, and they come back and say, okay, well, we'll advance you back up to the 1.68.
I agree, Your Honor. I've always acknowledged that if the bank had lent money, Mr. Saber, under Note 2, if despite the fact it's fully amortized and doesn't seem on its face to oblige the bank to lend him more money once he borrowed the full amount to begin with, then they'd have a better argument for being secured to the amount of 1.16. But then again, they would have been owed 1.168 under Note 2. The other question that the court posited, as I understand it, is if there's maximum lien language in a deed of trust, does that effectively make any loans lent to the amount of the maximum lien give it priority notwithstanding La Choya? And the response is maximum lien doesn't have anything to do with optional versus obligatory advances. It's either optional or it's obligatory. And if it's obligatory, it has whatever lien priority it has. But there's no dispute in this case, no serious one that I can see, that notes 3 and 4 were optional, not obligatory.
But doesn't the purpose of La Choya was notice? And you knew what was going on. Doesn't the maximum lien provision give that, saying, hey, even if they're optional, it could go all the way up to the maximum lien amount?
Well, if you agree with us that notes 3 and 4 were never secured, the answer is no. But number 2,
and I agree, I understand.
Yeah,
but let's assume, yeah.
Right. Bear in mind the note that was being put into place when my client consented to subordinate, as I've said one too many times perhaps, was a fully amortized loan with no provision for there being additional monies lent pursuant to that obligation. I don't have anything to add unless the court has questions. Thank you, Your Honors.
Counsel, we thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We're now adjourned.